Good morning, everyone. Thank you for coming along to today's webinar, Children in Police Custody, Implementing the Children Care and Justice Act 2024. My name is Pamela Morrison and I'm a Practice Development Advisor here at CYCJ, and I have the honour of chairing the webinar this morning. We're joined by Debbie Nolan, who's also a Practice Development Advisor at CYCJ, and Sergeant Claire Gemmell from Police Scotland, who will both have the opportunity to introduce themselves shortly. Both organisations are members of the National Children in Police Custody Group, which is established to promote practice, policy and legislative changes in relation to children in police custody, which has been established under the Youth Justice Improvement Board. The webinar today will provide information on the provisions of the Children Care and Justice Act in respect of children in police custody, which will commence on the 30th of March 2026. These provisions will remove the existing distinction between the treatment of older and younger children in police custody and instead align with UNC and GIRFEC to define a child as anyone under the age of 18. In this webinar, Debbie will firstly walk us through the changes the Act will bring and explore the practical implications of this. Claire will then provide an update on the preparatory work Police Scotland have been undertaking to get ready for these changes. I should mention at this point that the webinar supports a guidance document that has just been published on the Youth Justice Improvement Board website, which will also be shared on the chat of today's webinar, so please take the opportunity to have a look at this if you can. Following the inputs, there will be opportunity for participants' questions. We'll try to get through as many of these as we can, but we'll also capture these in a frequently asked questions document at the end of the guidance, which we will ensure that we try to update on an ongoing basis as new queries and questions arise. This webinar will be recorded and shared on the CYCJ website alongside the slides. So if there's any bits that you've missed, you will be able to go back and have a look and listen again. Cameras and mics will be switched off for all attendees. Only the speakers and organisers of the event will have their cameras on. You will, however, be able to use the chat function for questions, which we will try to get through at the end of the presentation. So please make the use of this if you can. As stated already, we'll be recording the webinar in order for us to share this on the CYCJ website. However, we request that attendees do not use any other recording devices, either video or audio, including those that are AI assisted. Finally, before I hand to Debbie, for those who are not so familiar with CYCJ, our vision is one where we work towards ensuring that Scotland's approach to children and young people in conflict with the law is rights respecting, contributing to safer communities and better outcomes for children, young people and their families. We're involved in a number of different areas of work, including practice and policy development, where we support the workforce, participation, ensuring children's voices are at the centre of our work, and research, which is all underpinned by knowledge exchange. We have an e-bulletin, which we will link to at the end of the month, at the end of the webinar. This comes out at the end of each month. But if anyone would like to hear any more about the work of CYCJ, please don't hesitate to get in touch. I'm now going to pass you to Debbie for the first input from the webinar. Thank you, Debbie.
Great, thanks, Pamela. And hi everyone, thanks for joining us today. It's great to see such a number of people on the screen. So as Pamela said, my name is Debbie Nolan. I'm also Practice Development Advisor at CYCJ, and I have been involved with the Care and Justice Scotland Act from when it was a bill and was on secondment to government as that bill was being developed. And since the bill became an act, I've been back at CYCJ supporting agencies as they prepare for the national level preparation for the Act commencing. It's been great to be involved in the work around about the police custody provisions, and it's really great to be able to speak to people about this today. So I'm going to start, as Pamela mentioned, with just giving this headline slide of what does the Act do. If this is the only bit that you take away from today, then try and keep this slide in mind. So as Pamela's mentioned, firstly, the Children Care and Justice Scotland Act in the police custody provisions defines a child as anyone under the age of 18. That effectively means that we will streamline our approaches to children in police custody so that they apply to all children under the age of 18, and is largely extension of what was already happening for some children, although there are some changes in that. In addition, in light of 16, 17-year-olds and their evolving capabilities, there are still some additional differences for 16, 17-year-olds, and I'll talk them through in a minute. Secondly, it's really important to remember that this section of the Act relates to children who've been arrested and are in police custody. They wouldn't apply there, for example, if the child hadn't been arrested or hadn't been brought into police custody. The exception to that being when the child comes into police custody for a planned voluntary interview, in which case the child would still need to have a lawyer present for that interview. Thirdly, because the Act is taking a sort of incremental approach to being fully rolled out, the Act, come the 30th of March, will not change the disposals that are available at the end of a child's journey through police custody. So what that means is that the existing parameters that mean only some 16, 17-year-olds can either be singly referred to the Scottish Children's Reporters Administration or can be jointly reported to SCRA and also to the Procurator Fiscal. That will still only apply for some 16, 17-year-olds. It won't be an option for all under 18s as yet. And when the Act fully commences, the age of referral to the reporter will increase, and we anticipate that being in spring 2027. Fourthly, as we'll talk about today, there's implications of the changes the Act brings in respect of police custody for police, obviously, but also for local authorities, for Children's Reporters Administration, for lawyers and for other agencies, but also for parents, carers and adults who the child might name, and we'll talk a bit about that just shortly. As Pamela's already said, the last two bullet points on this slide, the guidance has been published. We will keep updating that. That was developed by a Short Life Working Group and sits alongside single agency guidance that people may develop. However, it is multi-agency guidance and covers a range of different agencies. And as Pamela said, we're launching the guidance today with this webinar in advance of the provisions going live on the 30th of March. That is to give people a bit of time to think about, okay, what might these provisions mean for us, and how might we translate that guidance into our local arrangement or arrangements or our single agency arrangements. So those are the headlines. Now going to start going into some more detail of the different changes that the Act brings and what they mean and what they entail. So the first part of the changes relate to notifications and visits when children are in police custody. So we've split this into what that means for local authorities and what that means for other adults, and this covers all the different steps and stages throughout a child's journey. So in respect of the local authority first, at the moment, the local authority will be notified at some points when a child's in police custody for some children. What the Act does is really streamline that so that the local authority will have extended notification points, and we should never have a situation where a child has been in police custody and the local authority hasn't been informed. So what the Act does is that it makes changes so that where any child comes into police custody having been arrested, the local authority will be informed on that child's entry to police custody. The local authority will be informed as soon as practicable, and they will be informed first, so before any other adult is informed. The reason for that is because, as seen on the third one of this list, for local authorities, the local authority can also advise who should or should not be informed that a child's in police custody. So it's really important the local authority are informed first and have the opportunity to give that advice. There's information in the guidance about some of the factors local authorities might want to think about in giving that advice to the police as to who should or should not be informed. In addition to that, the local authority will be informed at other notification points. So for 16, 17-year-olds, they have more choice in who, if anyone, is informed that they're in police custody. And what the Act does is make specific points for 16, 17-year-olds, that would trigger a further notification to the local authority. So they would be, for example, if a 16, 17-year-old didn't want anyone else informed that they were in police custody, wanted someone informed but didn't want them to have access or be asked to have access to the child, or didn't want any further attempts made to inform someone else they were in police custody. And really importantly, we're going to talk about visits, but there are some situations where the police could refuse or restrict a visit to a child, and in that situation, the local authority would always be informed. So the local authority would be informed on entry, they'll have other notification points, and based on that notification coming in, the local authority can choose to visit the child at any time if they believe that a visit by the local authority to the child would safeguard and promote the child's well-being. In doing so, that will not impact on information being sent to anyone else or anyone else being able to visit the child. The local authority will just need to consider that they can visit within a reasonable time. At each notification point, the decision of the local authority to visit should be reconsidered or should be thought about. Does this new information suggest that we should visit the child? And it's best practice that a child will always be visited by social work while they are in police custody. Some areas have set timeframes whereby they do a welfare check to children. So they'll say within X number of hours, we will always see a child. Other areas have a more case-by-case decision-making, and the guidance document sets out some of the factors local authorities might want to think about in informing that decision. In addition, at the kind of more towards the end of a child's journey, the local authority will always be informed when a child is leaving police custody, and that will include if the child's been released unconditionally, released without charge, or if the child is being held to appear at court or released on an undertaking. That information will go to the child's home local authority. In addition, a vulnerable persons database form will be completed, which will be shared with the child's home area. But in addition to that, if the child is going to be appearing at court, justice social work in that local authority area of the court where the child's appearing will also be informed. And again, they should get away from a situation whereby children are appearing at court and no one knows that they're going to be appearing at court. When the child's held to appear at court or being released on an undertaking, the local authority often will have a duty to give the court information on that. And a shameless plug, we have a court webinar coming up because court changes through the Act will go live on the 30th of March as well. And we're holding a court webinar on the 30th of March, and the link will be popped in the chat if you'd like to know or hear more about that. In addition, while a child's in police custody, if the child's age 16, 17 and by virtue of a mental disorder is unable to sufficiently understand what's happening or communicate with the police should also seek an appropriate adult for that child. The appropriate adult role is set out in legislation, and that person needs to be trained to fulfil that role. So that is the points of the local authority notification and the times when covers local authority visits to the child post the 30th of March this year. In addition, the Act makes some changes in respect of notification and visits for other adults. So for anyone under 16, going forward, parents must be informed that the child's in police custody and asked to attend the police station. For 16, 17-year-olds, in recognition that 16, 17-year-olds are at different stage of development and that parental rights have ceased, but parental responsibilities have not, 16, 17-year-olds could ask for a named adult, so anyone over the age of 18 to be informed if they wish, and if an adult can be reasonably named. And if that adult is named, they can be asked to attend the police station to see the child if the child wishes that. Again, social work could give information to suggest a named adult should not be informed, and police would then make a decision based on that information. That named adult could, for example, still be a parent, but it could also be a friend, a partner, a spouse, a support worker, an advocacy worker, a lawyer, for example. In addition, at the end point of a child's journey, for all under 18s, a parent should be informed if a child's been held to appear at court or is being released on an undertaking. However, police do not need to do that if they deem it would be detrimental to the child. And the guidance includes some factors that police might want to take into account in making that decision. As I've mentioned, the legislation and guidance sets out when rights to notifications of visits could cease or could be delayed, or visits could be restricted or refused. And the guidance and legislation gives some more information on that. In terms of sharing information and telling these people that a child's in police custody, the child's consent is not needed for local authorities. It's not needed for under 16s. It is for 16, 17-year-olds for a named adult being informed, but the child's views would be taken into account. And what we're often asked is, if a parent, a carer, or a social worker is visiting a child in police custody, what is their role? Whether their role is to support the child by providing practical or emotional support. Their role is to provide information to the child. There's information in the Letter of Rights, which covers what can happen when a child's in police custody. That's just getting updated at the moment. And their third kind of role, if they're visiting the child, is to promote and seek to ensure the child's well-being. So that covers notification and visits of local authorities and other adults. However, in addition, there are some other changes and extensions that the Act makes through a child's custody journey. So in respect of police interviews, previously, children, some 16, 17-year-olds have been able to waive a lawyer being present in a police interview if a named adult agreed to that. However, going forward, a lawyer must be present for all under 18s during a police interview. The lawyer's role in that situation is to give legal advice, to ensure to represent the child and ensure the child's rights are upheld. There are very exceptional circumstances laid out in legislation that a lawyer, the police can interview a child without a lawyer being present, but that is only in very limited circumstances. If a child does not, if the police don't have those exceptional circumstances and a child refuses to refuses a lawyer being present or refuses to instruct a lawyer, the police can't interview the child, and therefore the options would be that the child could still be released, either conditionally or unconditionally. The child could be charged and could be either held to appear at court or released to appear at court. In addition, in a police interview, an appropriate adult could be present, which we spoke about earlier, what their role is, but there could also be an interpreter present if that is required. In addition, at the discretion of the police, another adult could be present during the police interview, and that could include a parent, a named adult, or a representative from the local authority. The guidance sets out some factors that police will take into account in informing that decision. Likewise, with visits, if another adult is present during these interviews, their role is very much to support the well-being of the child. It should be clarified in advance what that role can and cannot do, and also the roles should be agreed and explained to the child in advance of the police interview. In addition, then, when we're thinking about a child released from police custody as being considered by the police, if a child needs to be kept to be brought before court, they need to be kept in a place of safety. The place of safety can only be a police station if a certain rank of constable assesses that an alternative place of safety would be impractical, unsafe, or unadvisable due to the child's state of physical or mental health. Right now, that has been a consideration for under 16s and some 16, 17-year-olds. Now that would be a consideration for any child under the age of 18 who needs to be held pending an appearance at court. The definition of a place of safety is set out under the 2011 Children's Here in Scotland Act and effectively covers a very broad range of different places. So it could be a residential or other establishment provided by local authority, it could be a hospital or a surgery, or it could effectively be any other place that the person, the occupier or a suitable person, consents to that being used as a place of safety for the child. Secure care can only be used as a place of safety when the conditions under the secure care regulations are met. When a decision is being made about a place of safety, social work and police need to agree on that, but police will be the ultimate decision maker because the child is in police custody. It can be challenging to reach that agreement, and there's local variation about what is available as a place of safety. And typically there is not one dedicated place of safety that can be used solely for this purpose. Okay, so that covers the changes that the Act makes in respect of visits to children, in respect of intimations, in respect of the police interview, and in respect of places of safety. As I've said, a lot of that is extension, and a lot of that should feel familiar to people. However, we're just now going to briefly touch on what does this mean then in practice? What does it mean in terms of roles and responsibilities? And we've kept this quite wide given the wide audience we've got today. So in respect of roles then, this is kind of what at an individual and service level people might want to think about, but the prompt questions are also things that people might want to think about in anticipation of these changes coming. What do we need to maybe think about? So the first role is about enhanced information and assessment sharing. So as we said in the first slide of my section, there will be enhanced notification points coming from police and increased points where police need to make a decision about what approach to take with a child. However, social work will have a key role in gathering and sharing information to help inform that decision of the police. So, for example, about who the police should inform about a child being in police custody, about a place of safety, or about how a child should be released. So really important roles for police and social work there. In most areas, what we know is this information is already happening for some children anyway. And what areas are saying is we already have quite good processes for receiving that notification from the police, for gathering that information and giving it back to the police. But people might want to think about how is that working locally. If we've got more children that we're getting more notifications about and more requests for information, how will we manage that? And that's recognising that in particular, this will not happen Monday to Friday, 9 to 5. Often it will be out with office hours that this is taking place. The second kind of role is then the role of adults involved. So what is the role for parents or named adults if they are being asked to attend police custody? The role of appropriate adults is set out clearly in the legislation, and we've tried to give some more information about what are the roles of adults who might visit the child or be present in the police interview. One of the things that has come up through this work is that at times local authorities will be asked to provide a responsible adult for children. The responsible adult role is often requested when a child is the parent or guardian's not available, or the child's a looked after child, or the local authority has parental rights for the child, or the child's subject to children's hearings measures. That role is not defined in legislation anywhere, but actually that role would be similar to the one we've already outlined about the child's wellbeing, about providing support and providing information. So a question that agencies might want to ask themselves is about what information and support do we have already for adults who are fulfilling those roles, and what else might we need to give those adults so that they can do that to the best of their ability. The third role then is about visits, and we've covered what that visits would entail. And I suppose then the question for agencies is thinking about, for I suppose both police and social work, how do we decide if someone visits, when they visit, or who visits? And for social work, thinking about, okay, do we keep that to a case-by-case decision? Do we set timescales to that? And are we consistently thinking that through for making a decision as to whether the child should be visited or not, and when? Fourthly is the roles around about legal representation. Obviously, that role predominantly sits with the lawyer who would be representing the child. However, as I've mentioned, if a child refuses to instruct a solicitor, that solicitor can't act on that child's behalf. That's not a new issue. However, as we have 16, 17-year-olds not able to waive their right to a solicitor being present during the police interview, we might see more situations where children will not instruct a solicitor, and therefore, unless it's exceptional circumstances, police wouldn't be able to interview the child. So for agencies, we should be thinking then about how can we support the fulfilment of legal rights, and how can we monitor these issues. So in some areas, people have said, well, we can have difficulties accessing lawyers, or it can take a long periods of time. The Scottish Legal Aid Boards have advised in some areas it would take longer, particularly if it was a duty solicitor being accessed, but actually that there should be enough solicitors covering all areas. In terms of how long that takes, police every 4 hours will be reviewing a child's case, and they would be noting if there was issues with a child accessing a lawyer or the time being taken, and they could then escalate those issues to the Scottish Legal Aid Board. But in addition, local authorities should be mindful of that as well. Fifthly, there's key roles for agencies in identifying and agreeing places of safety. So whilst police, I suppose, will ultimately decide if a child will go to a place of safety, they do that based on the information provided by social work about what is available, what place of safety do we have, but really critically, not just the place of safety, what support can be provided alongside that. So what supervision, what contingency planning, who will be seeing the child, how often, what supports can be put in place around about that place of safety itself. That whilst social work will be the ones who would be identifying the place of safety and giving that information about support, there's also a role for other agencies in being part of that support package. So, for example, health, third sector organisations. There's also important roles for social work in being able to communicate that to the police, and also where there is a suggestion that this child might need to be deprived of their liberty and placed in secure care as a place of safety, the Chief Social Work Officer and Head of Unit of the Secure Centre have particularly legally enshrined roles. So really important that that assessment of whether the child could be placed in secure care and meets the criteria for that can be communicated to the police, and also the roles of those other agencies can be fulfilled. In addition to that, there are particular notification points for SCRA when a child's held in a place of safety and is not being prosecuted. So again, there's roles for different agencies here. There are also is an issue around about legal clarity here about when a child's in a place of safety, who is responsible for them, and police and social work have been advised to seek advice on that. We'll continue to try to find national level advice on that. So some of the prompt questions here for thinking about is what local availability do we have for places of safety? What support can be brought in at short notice? Bearing in mind the child is likely to be in a place of safety for a relatively short window of time ahead of them appearing at court. What support can be put around that? What is our decision-making process, and how do we, social work and police, work together to agree what an appropriate safe place of safety is? How is that recorded? How are differences in views addressed in a short term and longer term? In addition, just coming to the second last point here, the roles are about a key role about support with disposal and parental information. So when a child is being released from police custody, what support can we provide to that child in terms of understanding what the disposal means? For example, if they're being released on an undertaking, how can we support the child to understand what the conditions of the undertaking are, and also support them, if appropriate, to comply with those conditions? And what information can we give to to parents about when a child's leaving police custody, this is the next steps and what's going to happen. So a prompt question might be, how can we provide that support, and what information can we provide? And then lastly, a key role here for everyone involved is about upholding the child's rights. That includes rights to protection, and everyone involved should be being mindful of, does this child in police custody, are they at risk of significant harm, and child protection procedures might be appropriate, or could that child meet the legal criteria under adult support and protection, and therefore those procedures should be invoked. But also thinking, if this child is at risk of causing harm to someone else, be that another child or adult, should either of those processes be followed as a result? And it's also for everyone involved being alert to unintended consequences here. If that child is made subject, for example, to an undertaking that is very restrictive, we know children can struggle to comply with that. What might be the unintended consequences and risks of that, and how can that information be shared with the police to help inform decision making? So the question here is thinking about how can we make sure staff understand that, are alert to all those matters, and how can we address and balance where there's maybe rights challenges or issues around about that. So that was a very quick whistle-stop tour about, okay, you've heard about what the changes the Act are bringing, what might those changes mean for me, my organisation and my service, and what might we need to think about between now and the 30th of March and these provisions going live. So I'm going to hand over now to Claire to talk through the preparatory work alongside this multi-agency work that Police Scotland have been undertaking on a single agency basis. Over to you, Claire.
Thanks very much, Debbie. Hi everyone, thanks very much for coming today. My name is Claire Gemmell. I'm a sergeant within CJSD policy. We are the lead for the Act and the implementation of this Act for Police Scotland. So myself and my team have been doing a lot of work in this over the last year and a half or so. So really, I'm just looking to give you a brief overview of just the work that Police Scotland have been doing in preparation for this Act, most specifically Section 15 coming in the 30th of March. Debbie, if you could move on, that would be fantastic. To the next slide. Thank you very much. So, as I said, it's really just to give you an overview of the preparation we've done, what support is currently in place for children in police custody, and what guidance and training that we have compiled together and put out for Police Scotland employees so that they feel confident in their roles and responsibilities when the Act comes in the 30th of March. So really, in terms of preparation, Debbie, sorry if you could move on as well, thank you. So just in terms of preparation, really that initially started with us consulting with our internal business areas, and that was really just to establish how they felt that the Act might affect their business area and business processes, just so that we didn't overlook anything and made sure that every area was covered. So for local policing, on the 30th of March, you know, there'll be no real change, I suppose, for local policing, because this is all relating to children actually in police custody. But I suppose what it is key to reiterate to them is that 16 and 17-year-olds not under supervision can't actually be referred to SCRA until the full Act is implemented in 2027 or March 2027 it's scheduled. Then obviously we had to discuss with different training departments, you know, what their materials were and what they're currently teaching, just so they're aware of the updates. So for instance, probationer training for new recruits coming in, we have to make sure, I believe there actually is a new probationary recruit starting in a few weeks. So we'll need to make sure that all the training and stuff's up to date so that they're getting taught the right things for the Act coming in, along with detective training and also CJSD training, which is primarily the main thing, given a lot of this in the first instance is to do with children in police custody. SCD as well, Specialist Crime Division, they have a lot to do with obviously children normally come into custody for more serious offences, and it is themselves that will be interviewing them and doing everything to do with that in terms of their access now to solicitors required for interview. But more specifically, the public protection side, so in terms of the vulnerable persons database. So we've had a lot of kind of back and forward with public protection and SCD in relation to the vulnerable persons database. But actually that has actually already been updated and changed. So on that database, every child under 18 is considered a child, although with social work, etc., it's still over 16 that would be considered an adult, but we already have the functions in place where once the full Act commences, then basically there's no change required. Effectively, we've got everything in place there to suggest that what the child needs for support is in place ahead of that. And then really the biggest change is for my division, which is CJSD, and that's in terms of custody practices and basically IT at the side of that to make sure that that reflects the changes that are coming in. So over the last few months, myself in particular have been involved with our IT department to update our national custody system, and that's to ensure it reflects the changes to the Acts in terms of the rights of a 16 and 17-year-old not under supervision, in terms of the notification to the local authority, notification to a reasonably named person or parent or guardian, and also the PIROS form in terms of their access to a solicitor ahead of police interview. So Debbie, sorry, if you could just move on, please. So that just brings me on to support for children in police custody. So as we're talking about, all under 18s now being considered a child in terms of the child detention certificate, as you'll be aware, that was normally only completed for under 16s or 16, 17-year-olds under a supervision order if they were to remain in police custody for a court appearance. That will now be required for all under 18s if they are to remain in police custody for a court appearance. But we have updated that to ensure it's compliant with UNCRC. So basically there's a section added to the form which will consider the views of the child. It's not to say that that will necessarily change the outcome of the child being in police custody for court, but it's more about allowing them to raise their concerns or any support or anything like that that they might need or have at that point in time, that we can record there and look to put things in place for them. In addition, it's a policy that has come in probably in the last 6 to 8 months regarding the review of a child in custody. This was always reviewed, but it is changed now where it's done more frequently. So when a child's brought into custody, the custody sergeant has to put justification on to the custody system for the necessity of the child being in custody, identifying any vulnerabilities that that child might have, and also noting what we are doing to basically provide support for that child, whether that be through the local authority, a parent or guardian, whatever that might be. And that actually has to be overlooked by the custody review inspector, who, if they feel there's any gaps in that or there's more questions that they wish to be answered, that will be discussed with the supervisor, and that will then have to be done and then updated on the system. And once everybody's satisfied that yes, this child, unfortunately for this moment in time, has to be in police custody, but that will then be reviewed a minimum of every 4 hours. So it's not saying it should wait 4 hours to sit for it to be re-reviewed. If other information comes to light or anything at all, the child raises anything, local authority raises anything, that should be looked at to see if it is still compliant and still in place. As well as that, there was work ongoing with our case management unit with partners in relation to children appearing in undertakings. And I know it's been raised previously from local authorities where maybe children are turning up to a court at 9 in the morning. That shouldn't be happening. It has been agreed, and there is agreed times for every single area, where if a child's been released on an undertaking, there is a specific agreed time between courts when a child should attend, so that it prevents them from sitting at a court all day waiting in their court appearance. So that has been cascaded around Police Scotland custody sergeants, so it should be aware and it should not be happening where a child is basically going to court at 9 in the morning and having to sit and wait for a 2 o'clock appearance. As well as that, there's a pilot ongoing where, as you'll be aware, London Road Police Office is a child custody centre. They've got a discrete charge bar. There is a screen up on the wall which allows the child to see like an animated video, which basically provides the child with information on their rights, the custody process and the criminal justice process. It just ensures that all young people receive consistent information in an age-appropriate format, hopefully reducing any misunderstandings or stress, or alleviating any kind of fears that they might have. But recognising that that's not the case for the majority of police custody suites, then we're looking to introduce a video brochure. So that's basically like a small cardboard book, which when you open it, it displays a screen. It's got buttons on it where you can pause it, rewind it, fast forward if you have to, if they want to look at something again. And that will contain a video similar to the one that's shown in London Road Police Office, which will explain all the rights of the child in a friendlier format for them. So we're hoping to have that rolled out where it will be available to all custody suites across the country, but work is still ongoing with that. As well as that, I am aware as well that there's a pilot running in Glasgow for all under 18s, which would allow children to confidentially speak with Childline, and that's in partnership with the NSPCC. Again, that was piloted in Glasgow, and the hope is to roll that out across the country as well, just so that when children do come into custody, they feel as if that they do have somewhere to go and they can speak to folk, and it's not just the police dealing with them and they understand exactly what's happening with them in terms of the custody process and the court appearance. Debbie, sorry, if you just move on, please, thank you. So that just brings me on to the training and guidance that we've compiled for Police Scotland employees. So just last week, a news brief went live ahead of the Act coming in the 30th. It basically is just an overview of what the Act is and what the Act's going to bring. And it's really just to give folk a reminder of the fact that, you know, this is coming in, the guidance will be coming out and the PowerPoint will be coming out, just to keep an eye looking out for it. Hopefully they will be approved and released on the Friday the 13th of this month. So that should give folk 2 weeks to get themselves familiarised with what's expected of them and what the Act actually changes. In terms of the guidance, that's really more in depth in terms of what should be considered, more from custody supervisors, when people should be notified, when a parent or guardian should be notified, when the local authority should be notified, the changes, as I said, in respect of children being interviewed in custody, but also in addition to that, you know, discussions with the local authority and what types of things that we should be considering when we're discussing the child with the local authority in terms of, you know, are they in the care of a parent or guardian? Are they a looked after child? Are they under a child? Is there any child protection concerns? What's the risks? What's the vulnerabilities? And that goes both ways in terms of maybe what the police have observed in dealing with the child, but also what the local authority might know from the child's past. And as I said, just the expectations on the police and partners in terms of the Act. The training PowerPoint goes into kind of more examples, kind of more practical examples as to when and where the Act will influence. So, for instance, out with police custody, it's just trying to reiterate the fact that a child can't be, at this moment in time, referred to the children's reporter. But once they come into police custody, this is the changes, this is what we need to do, and this is what we should be thinking about going forward. As well as that, it's about obviously the fact that a CDC will now need to be done for all children under 18, and we should be really considering, as we should be anyway, if it's appropriate to be bringing a child into police custody. So what's the nature of the offence? What's the context of the crime? You know, the age and stage of the development of the child, the safety and well-being of the child or children involved in the offence. All of these things should be considered when deciding whether or not it's appropriate to bring somebody under 18 into custody. As well as that, you know, discussions with the local authority, just as Debbie had touched on, about whether it's detrimental to the well-being of the child to notify a parent or guardian if a child's been released in undertaking, or if they've been held in custody, for a court appearance. So these decisions, it is for the police to make the final decision. But it's obviously important that we take the experience and knowledge of the local authority to then inform these decisions going forward. But it will be the decision of the police as to whether we do inform or not inform, and we should document that on the national custody system as to what we have or haven't decided to do as a result of that. It also touches on section 16 very briefly of the Act, which is obviously in relation to children appearing at court and the fact that they should be held elsewhere in a building. It's just to be mindful that there is occasions where police do transport children to court for a court appearance, but that we should be consulting with SCTS on that before taking the child to court, so we're taking them to the appropriate place in the building and not just turning up where they're going in where they're adults. If you would move on, Debbie, I've tried to pull together just an example, you know, of where the Act might bring in changes or considerations for what a custody sergeant or custody staff should be considering when a child is brought into custody. So I'll just go through this here. It might just give you something to think about. So Sarah is a 17-year-old, not under supervision. She's been arrested, not officially accused, to facilitate further police inquiries after being verbally abusive to her boyfriend. On her arrival at at police custody, she's booked onto the custody system, during which she declines to have a reasonably named person informed of her arrest, which under the Act she can do at that point in time. So as Sarah is under 18 years of age, she's required to have a solicitor present during a police interview. But during the PYROS question, Sarah declines to have a solicitor informed of her arrest, declines to have a phone consultation, or to request a solicitor be present during the interview. So as a result of that, it means that, and the solicitor's not acting on her behalf, it means that the police cannot interview Sarah regarding this crime. Further inquiries reveal that the verbal abuse was overheard by a mutual friend. So as a result, Sarah was charged with Section 38, effectively threatening abusive behaviour. So upon review of the information, the custody sergeant decides to release Sarah in an undertaking. As she's now been released in an undertaking, a parent or guardian must be informed. Sarah refuses to have a parent or guardian informed as she is estranged from her family and lives independently. The custody sergeant discusses this with the local authority and considers all available information regarding Sarah's background and her views. It is agreed that it would be detrimental to the well-being of Sarah to inform her family, and the rationale for this is recorded on the custody system. As this is Sarah's first time in police custody, the local authority visit her to ensure her well-being and offer support. Once the undertaking paperwork has been processed, Sarah is asked if she wishes anyone present for her release. Again, she declines, which is recorded in the custody system. The custody sergeant is satisfied to release Sarah into her own care, as she has no vulnerabilities and has lived independently for some time. And just on top of that, although the local authority have been informed that Sarah has been in police custody, an IVPD, which is the Vulnerable Persons Database, must still be submitted by the reporting officer to detail all the circumstances of that arrest. So that's just to give you something to think about and where the changes, things might be slightly different. I don't know if anybody has any questions or anything as a result of that scenario, but I just tried my best to cover most eventualities that could maybe come up or cause issues or raise red flags. But again, thank you very much for listening, and I'll welcome any questions that anybody might have.
Thank you very much, Claire, and thank you, Debbie, as well. An excellent overview of the changes, what this means for the different organisations supporting children in police custody, and also some of the, I suppose, the background work of what Police Scotland are doing to try and help day to day the children that are within their care. It's such a huge organisation, but it appears that you've been able to engage with the different sections within that to try and have a clear strategic process to this. So thank you for sharing that with us. A reminder for attendees, if you've got any questions for either Claire or Debbie, to pop it in the chat and we will get those questions asked to them. There's one here that's specifically for yourself, Claire, and it's asking the video book that you mentioned that's been planned for children in custody. Will that be left with them unsupervised, given the history of various materials being used for self-harm in custody environments?
No, it will be supervised while they're using it. It will obviously not be for them specifically, it will be used again and again for children in custody, but they'll have to be supervised when they're looking at that video.
Yeah, so there's a risk assessment round about the use of these things. Thank you. Okay, so this one's in and from a social work perspective, so possibly for yourself, Debbie, is there anything that can be done if a child is accidentally brought to court at 9 AM for an undertaking? And through the kind of preparatory work, and I know that this has been an issue for quite a lot of areas.
Yeah, no, a really good question, and as Pamela said. So we think at times part of the issue is that either police are transporting the child and there's not, police are told that it's X time and they aren't aware that locally actually there's a different time agreed. So Claire, through her work, has redoubled efforts so that all areas of police understand the time for their local area. In addition, what we're also seeing at times, the undertaking slip that the child gets says it's 9 o'clock, and then the child's, however well social work say, no, by the way, it's not 9 o'clock. Sometimes children and their family don't want to do anything wrong, which is understandable, therefore we'll go at 9 o'clock. So again, through Claire's work, we would hope that the undertakings were clearer for the locally agreed time. The second part of this is colleagues from COPFS have also looked at just trying to, if at all possible, telling people ahead of an undertaking if, for example, the case isn't going to go ahead at that set time. If you are appearing and you arrive at court and are being told, oh, actually, Johnny's not appearing till 2 o'clock or whatever, in that situation, I would be suggesting that you discuss that and come to an agreement that the child comes back at that time. So giving the child and whoever's with them really clear instruction and understanding to come back at the appropriate time, or reach some kind of agreement that that child can wait elsewhere, be that in the court, if there was a separate age-appropriate facility for the child to wait at court. That, I don't think that's the best approach, but potentially local authorities or another agency could maybe offer somewhere else where the child could wait ahead of that appearing time. If that is becoming a prevalent issue in your local area, I would suggest that it's being flagged to agencies locally, so local courts, local police, local PFs if that was appropriate. And in addition, super happy for those sorts of issues to be flagged to CYCJ as well, and we can look at what we could maybe do to support that at a local or national level. So I'm not sure if anyone's got anything else to add on that, Claire, or anyone else, or if that answered the question sufficiently.
Yep, thank you. Do you want to come in, Claire? Are you happy with that?
No, I'm happy with what Debbie said, thank you.
Okay, this question I think kind of follows on from that as well in relation to holding cells. So looking for some clarity around when this is deemed necessary and what provisions are in place to hold in waiting areas, family rooms to reduce fear, trauma, etc. I know that Debbie, you've been involved in the court work as well, so it might kind of come into some of the work that you've done there also.
Yeah, so I'm assuming that means like holding cells at court. So at the youth justice standards are crystal clear that children shouldn't be being held in cell areas of court unless they absolutely have to. Locally, instead, children should be being held in an ideal world, children will have will kind of know what time they need to appear at court, so they're not there for lengthy periods of time, although we know there's real challenges with having, for example, fixed times for children to appear, or there can be a raft of issues that mean the child can't be heard, their case can't be heard until later on in the day because they're awaiting paperwork or decisions to be made or whatever else. However, what we would encourage is that when you know a child is going to be appearing, that discussions take place with relevant partners, including the Scottish Courts and Tribunals Service locally, as to where that child can wait whilst they're waiting for their court appearance. What entrance can they use to court? Where can they wait? Can a separated, dedicated waiting room be made available for that child and anyone who is supporting them? Most courts do not have a designated specific, this will always be a child's waiting area, unfortunately. However, most courts will have a separate area that could be used, but that will depend on what other court business and for what other purposes that facility is being used. So really having that early conversation about where can this child go, where will they wait, would be beneficial. Also thinking through who's going to be waiting with that child and supporting them during that window of time, and trying to come to that agreement as far as possible ahead of time. As was mentioned, we've got the webinar on the 30th of March. As part of that, we've been developing a guidance toolkit covering children's rights at court, which will be launching on the 30th of March. And what we're really encouraging is local partners to take that toolkit and think about to local court liaison groups or whatever kind of local groups they have, and be thinking about, okay, what actually is our approach to children appearing at court? What can different agencies provide and offer? And I think there's something really important, that if your local court cannot provide suitable children's environments. What other things can we offer to the court? What other premises, what other facilities, what other options can be offered, so that we're trying to think as creatively as possible to try to get it as right as we can for children.
Thank you. Okay, so the questions are coming in thick and fast now, so I'm not sure we'll manage to get through them all, but we will try and capture them in the guidance document afterwards. A practical question here, if a child is out with a local authority and public transport is limited for the family member to be present, are the family members supported, and could this delay police work? Claire, do you want to take that one?
Yeah, sure. Yeah, obviously that could happen, unfortunately, where a child's maybe arrested and taken to a custody suite that's out with the local area. Obviously it would depend on the initial circumstances in terms of getting a parent or guardian to the police office. You know, if it was possible that officers could collect them and bring them there, it would maybe be an option. I'm not saying that would be the option on every occasion, but we would do what we could to try and facilitate the adult coming. If for whatever reason they couldn't attend, you know, I don't know, maybe they've got other children or something like that they can't attend, is when we would maybe look into a local authority, maybe identify somebody else, or maybe for their support. But unfortunately I don't have a all meets all answer. It would just, you would just need to wait in the circumstances, and as it must happen just now, you know, we would just deal with it as best we could at the time. I know, sorry, that's probably not the answer you're hoping for.
Thank you. Okay, if a child requests that someone attend the station whilst they're in custody, and are there any restrictions on who that person can be? For example, if the child requests someone that may also be an adult co-accused. Claire, I don't know.
Claire, do you want to jump in? Or?
Yeah. So again, it would all be individual circumstance in terms of what we know about the incident. So obviously if it could potentially be an adult co-accused, for obvious reasons, we probably wouldn't allow that visit, which is where at times you can obviously restrict access to a particular person, just given to protect the investigation. But sorry, I'm just looking for that question again to make sure I'm not missing any of it. The child with some attendance restrictions. Yeah, so it's unlikely that an adult or a parent or guardian would be restricted to see a child. It rarely happens. To be honest, it'd have to be a very good reason, but something like that, you know, they're potentially a co-accused to that crime, would be a reason that we would maybe restrict access to that child.
I just think another really important point there is, and this is where social work has a really key role, it's also about the well-being of the child. So actually, if a child is saying, I want so-and-so to come, but social work are really concerned about exploitation or violence or abuse within the context of that relationship, social work would have a really critical role in advising police of that background knowledge and information that might be available to suggest that it wasn't appropriate for the child to be there, for the child to be visited by that particular person. The guidance does give a little bit more about the legal parameters to this, but also some of the practical considerations and factors that local authorities and partners might want to take into account in thinking about, is that person appropriate or not?
Thank you. And for the purpose of time, I'm just going to take one more question. So within the scenario, it says that once a decision has been made to release the child on an undertaking, the local authority will visit. Will the child then continue to be held until social work attend?
Yeah, I'll come in on that. Sorry, it's probably more the way I've written the scenario, to be honest, because obviously once the child came into custody, the local authority would be informed, so they would know. All I was trying to reiterate there was that social or the local authority would decide to visit the child, but you know, you're not going to hold a child in custody for an additional 4 or 5 hours if social work can't make it out to visit them in a reasonable time. So no, you wouldn't be holding somebody in custody for longer than necessary, just to allow that to happen.
Thank you. Have you anything to add, Debbie?
No,
Yeah. Okay. Okay, thank you very much to both Claire and Debbie for this webinar. I was going to say this morning, but into this afternoon. And thank you for everybody for attending. As we stated before, the recording will be on the CYCJ website alongside the slides. And there'll also be a link there to the guidance document which we've discussed. Though questions that we've not managed to get through, we'll have a look at, and where we can incorporate them into the frequently asked questions document as part of that. As Debbie had already mentioned, we have the court webinar coming up at the end of the month, so there's still the opportunity for you to sign up to that, and also the link that Sally has just put in for some other webinars as well. Debbie's helpfully put up the e-bulletin sign up as well. So for anybody who's not signed up to our monthly e-bulletin, I recommend you do. It's the best thing you'll read all month. So the QR code is up for you to do that. We also have on sale now tickets for our Youth Justice Conference, which is our annual event, which is a day-and-a-half event in June each year. So again, the link is there. And I would recommend everybody who can to come along and join us on that day. I think that's everything that I've been tasked with letting you know. All that I've left to say is thanks again for joining us, and enjoy the rest of your day. Thank you.